Hello? Yeah, okay. Good afternoon, everyone who is here in Geneva today, and good evening, good morning to those of our friends who are joining from around the world. I believe there are 80 to 90 people already watching with great interest what we are going to speak about. This is a fascinating topic, and it not only involves the classic human rights conundrum of extractive industries and conflict, but it also takes us about what is being done at the end of it when it comes to the elusive aspect of remedy. But before I give introductory remarks, let me introduce our wonderful panel, which has many old friends and many familiar faces in the audience too. To my extreme left, which has nothing to do with his politics, is Egbert Wesseling from Pax, who has been championing and working on the Sudan case since as long as I remembered. I came to Amnesty International in 1999, and yeah, and I see my former Amnesty colleague Daniel, who has just celebrated 30 years at Amnesty working on business and human rights. Anyway, yes. She and I, we were among those who were working on it. And, Egbert, we had many interesting encounters with you since then. Then we have Olaf Björnsson, who has done enormous amount of work through Swedwatch, where he is basically looking in particular at institutional investors and their role. I'll briefly explain the context in 5 minutes after that. The next to that is Tara Van Ho, who is from University of Essex Human Rights Program, one of the finest programs in the world, and she's an incredibly good regular critic of what's going on Twitter or X. So I would definitely recommend you follow her. And to my immediate left is Anita Ramasastry, who needs no introduction. She was the queen of everything she survived until recently as part of the UN working group, but she's done much more than that. She's been involved with many other initiatives, most recently on modern slavery, and earlier, of course, besides that, she teaches human rights law at the University of Washington. So that's by way of introduction. I'm Salil Tripathi. I work with the Institute for Human Rights and Business. Just to give a background, Sudan used to be one country, most of us know that, and there was a bitter civil war through the 90s between the north and the south. There were oil fields in the south, and because of that, the government, the Air Force started bombing that region. Conflict escalated. The south wanted to secede. It became an extremely brutal conflict, and a lot of oil companies got implicated. Shell, again, those of us who've been campaigning for a long time will remember that Shell was implicated for providing aviation fuel to the Air Force. Talisman Energy, another large Canadian company, was involved with it and again had lawsuits against them, which were heard by the Presbyterian Church of Sudan. All that is part of the history, but one of the not as visible entities operating there, and probably with a much more difficult record to defend, was Lundin, a Swedish oil company, which was present there. And of course, after Talisman left, the Chinese, Malaysian, and Indian companies took over, which reduced the leverage of the international community to work in the Sudanese space. But Lundin was involved. Lundin kept telling us, Lundin had representatives here in Geneva who would tell us that don't worry about it, things are fine. We follow the international principles and everything will be all right. And as we know from the work of people like Olaf and Pax and Egbert, it was not all right. And there were serious issues of complicity. And this is where the remedy becomes interesting, that ultimately what Lundin decided to do was to sell off its assets. And it kept the profitable part, which went to the company called Aker, which is in Norway, which also has an interesting human rights background. And the bad assets were put in another part. So in case, whenever the case, and there is a case going on about which we'll hear more, there is a criminal case and the NCP. So in case the case becomes significant and assets have to be seized, the assets they'll be able to go after will be dud assets. And this is not something fundamentally new. I come from India, and Union Carbide and Bhopal, those of you who have long memories will remember when Union Carbide sold its assets and became part of Dow Chemicals. It sold all the assets around the world to Dow except the Indian unit, which was sold to a state-owned company in India. Which means if and when there is a judgment where people will be able to go after those assets, they will have nothing to get out of it. And the criminal complicity trial has been going on against two senior executives of Lundin, and there is the NCP complaint. And we have both Tara and Anita who have been expressing their views on it. They have made a submission about. They will tell us more about it as we go along. I know that Egbert, are you speaking first or is it Olaf? Yeah, okay. So we start with Egbert, then Olaf, then Tara, and then Anita. Thank you. Sorry for the long introduction.
Well, thank you very much, Sadil. Yes, good morning. So my name is Egbert Westlink. I'm working for Pax, Dutch Peace Movement. We've been... Is it? Okay. Yes. Hello. My name is Egbert Westlink. I'm working for Pax, Dutch Peace Movement, and we've been working for over 20 years for with a strategic objective, in this case, of remedy and reparation for the victims of the oil war. The thought behind that is that we believe that unless justice is done, there can be no reconciliation and no sustainable peace in this part of South Sudan. We are now 2.5 months into the trial that is scheduled to take 2.5 years, which is extremely long. The planning is until March 2026 hearings, and then we'll probably have to wait for another year for a decision by the court. So it's a very, very lengthy trial. The charges are aiding and abetting crimes against the law of nation, grave crimes, and probably the prosecutor will ask for 10 years of jail time for the suspects. In addition, very interesting, the prosecutor has requested the court to declare the entire operation of Lundin Energy in South Sudan a criminal enterprise and forfeit all profits for a total of about 220 million euros, which is a considerable sum of money. The basic legal argument is that the suspects on 11 occasions have requested the Sudanese government to provide security for their operations, knowing that this government routinely committed war crimes as a method of warfare, and that the new suspects knew of this, of the risk, or at least were indifferent to the risk that the security provision by the Sudanese government would be conducted in a criminal manner. The mental mode of intent is reckless intent here under Swedish law, which means that they were aware of the risk of a criminal outcome of their acts and indifferent to the consequences of basically their security needs. The accused deny all charges. They have a massive, very impressive legal defense team behind them, or 3 legal defense teams, in fact. And there are a lot of lawyers in court every day. The suspect really deny all charges to the greatest detail. They deny that the type of warfare was one as understood under international law. They deny that war crimes have been committed. They deny that the suspects had decisive influence over security policy of the company. They deny basic facts and very strongly accuse NGO reports that the prosecutor uses as evidence as biased and based on false information and hearsay. So yeah, it's a huge battle. And very recently, last Friday, in a shock decision by the court decided to throw out the civil claims of the 32 South Sudanese plaintiffs. And the consequences of that is that after a conviction, they will have to file each their own separate legal claim for remedy and reparation, which probably effectively denies them access to justice, because they will then have to pay for their own lawyers. And also, they will have to provide about 50,000 euros deposit as a security in case for the legal cost of the suspects in case their claims are thrown out. So it's a pretty dramatic decision that will be appealed. And this morning there was another spectacular news, which is that one of the plaintiff's lawyers have accused the court of bias, and I believe that means that he requested a replacement of the chairman of the court. So consequently, proceedings have been suspended this morning. Pretty messy. I have no idea what the consequences are, but delays, which has been a major problem, partly due to the extremely aggressive defense of the suspects, partly due to the complexity of the case, but now also due to this legal disagreement that I hope will not frustrate the case any longer. That's it for me for now.
Love, over to you.
Yes, I've been asked to tell you all a little about the NCP complaint that Swedwatch has filed together with Pax and 6 other civil society organizations. And kind of the background to that is that these 2 suspects were indicted in November of 2021. And immediately after the indictment, we know that the company started looking into what they called strategic alternatives that could include merger or asset disposals. And after only about a month after the indictment, it was announced that Lundin Energy was merging with Aker BP, which is a Norwegian oil and gas company. And in the merger agreement, it was agreed that these 2 companies would merge and become one, with the notable exception that 2% of Lundin Energy would be carved out, and these remaining 2% would carry any risks and liabilities related to Sudan. I think the wording was that this company would be the sole owner of any non-Norwegian potential liabilities related to past operations. So but the problem in this is that there is simply not enough assets in this small company to cover any remedy. And to be frank, I mean, there is probably not enough assets to cover the direct costs of the trial. So what happened, to be clear, is like in one swift stroke, the responsibility to remedy the victims ended up in one company, and the financial means to remedy the victims ended up in another company completely. And we have argued that this issue would have been addressed if a proper human rights due diligence had been conducted ahead of the merger. And this is also at the core of the complaint that we filed to the Norwegian NCP against Aker BP and its main shareholder, Aker ASA. So we argue that this failure to conduct human rights due diligence, through this, the companies contributed to and are still contributing to the denial of the right to remedy for these victims. And considering that the right to remedy is a human right in and of itself, through a proper human rights due diligence, Aker would have, identified, addressed, and be able to account for how the merger would impact the right to remedy, which is an actual and ongoing human rights impact. So the complaint was accepted by the Norwegian NCP, and we were invited to a mediation with the complainants and the companies. Unfortunately, we failed to reach a mediated agreement, and we're now waiting for the final opinion of the NCP in this case. And I mean, getting clarity on these issues is for us, it's extremely important, not only in this case, but also going forward. I mean, if you look at the specifics of this case, I think it's pretty obvious that through mergers and acquisitions, a company can impact human rights, and denial of the right to remedy is one of these rights, and that's why it's so important that companies are not allowed to kind of structure the way out of responsibility for human rights. Thank you.
Yep, Tara.
Okay, so I want to start by thanking Swedwatch and Pax for putting this on, but also for allowing me to intervene in the case. The reality is Egbert talked about the case, and I more or less pounced on him afterwards and was like, please let me help you. Let me do whatever I can to help you. And interjected myself into this case because I think it's such a fundamentally important one in terms of what we talk about when it comes to remedying victims, truly remedying victims, and the relationship between human rights due diligence and this right to an effective remedy. There's a sense in the guiding principles, because we talk about these three pillars, that due diligence and remedy are somehow distinct components or distinct expectations, but they're not. They're intertwined, and you see that within the guiding principles themselves when the guiding principles say that the culmination of human rights due diligence is that right to an effective remedy. That it's not supposed to be the denial. It's not a separate process. You don't end after identifying your risks or mitigation. You conclude when you have an effective remedy. So I want to start back. I want to pull back a moment just to note that Lundin, this case fits into a larger pattern that we saw in the 1990s and in the early 2000s of companies entering into authoritarian regimes, asking the authoritarian regimes to secure their interests, and then being shocked that authoritarian regimes do what authoritarian regimes do. And it's a little distressing that we are still discussing this case in 2023, that there's been such a denial of responsibility and such a denial of expectations, initially by the company, but also by the Swedish prosecutors. For a very long time, this reticence to even begin the investigation. So it was 2010 before the investigation began. And that's a quite long delay in justice for the victims. I do, however, now want to praise the Swedish prosecutors for eventually picking up the task. These kinds of prosecutions remain rare in international law. You will often have domestic states take responsibility for their own corporations, but talking about the transnational nature of a case like this and looking for the prosecution is quite rare. A case of this level is one we haven't actually seen since the Nuremberg tribunals, when again you had individual executives tried for the conduct of their corporations. So it's good that we are seeing this. I am extraordinarily distressed, and I'm going to take the Swedish government to task here for a second. They have a responsibility, the Swedish government, the primary responsibility in international law always rests with the states. So when we talk about the business responsibility, it's a subsidiary or secondary responsibility that sits alongside and is complementary to what the state has to do. But the fact that Sweden has a system in which victims from South Sudan would have to pay 50,000 euros of a deposit for the security of a company's legal claims is a denial of remedy. Like, I'm gonna say it's not just maybe a denial of remedy, it makes it unaffordable and inaccessible, and that's one of the core components of what we require when we talk about remedy, and I'm gonna get into remedy a bit more in a second. So I'm glad that the decision is being appealed. If it is not successfully overturned within the Swedish courts, I do hope that it goes to the Human Rights Committee for an individual complaint, because I think that they would take it to task. So this case, at its core, when we talk about it from a legal perspective, raises a question of how do we define international human rights and what we're expecting from businesses, because it's very clear under the guiding principles, but also under international law, that there is a right to an effective remedy, but also that there are bodies that are entrusted with elaborating on what that right means. States have elected the Human Rights Committee to determine what does the right to an effective remedy mean within the context of the International Covenant on Civil and Political Rights. You have similar bodies like the European Court of Human Rights, all of whom have been entrusted by states to tell us what a remedy is. And unfortunately, in this case, when Acker did its due diligence, or didn't do its due diligence, I'm not gonna make a factual finding there. I will make the factual finding that they either gravely misunderstood what a remedy is, they ignored the right to a remedy, or they applied it extraordinarily badly in this case. So what is a right to an effective remedy? First, it comes from the Universal Declaration of Human Rights, but then it has been incorporated into numerous treaties, including the ICCPR. And that's a relevant one, because when you talk about war crimes, when you're talking about the war crimes that we are talking about in this case, they are breaches not just of international humanitarian law, but they are then read into and interpreted in light of the rights to life and the right to freedom from torture within the international covenants. You also, again, have this recognition within the UN guidelines and basic principles on the right to a remedy that elaborate what do we expect. And again, somebody who was entrusted by states to help us understand what remedies are. So when I talk about a remedy today, that's who I'm relying on. I'm relying on what these experts at states have said that they trust to define a remedy. So this is not Tara Van Ho speaking. because even though I think she's pretty fabulous, states have yet to agree with me on that. So it's important to really go back to the source and to say, who are we expecting businesses to listen to? And when I talk about human rights due diligence, it is fundamental international human rights law, and that means you do the fundamental work of figuring out what are in the general comments, what is in the case law, what do we mean when we mean a remedy. It is not up for individual businesses to decide. It is not up for them to determine that it is a moment in time or something that is beyond their remit or their control. So a remedy has two components to it. It's the process and the substance. It needs to be a procedure that is capable of bringing about a resolution to a complaint and capable of rewarding or awarding to the victims the substance necessary to restore them to the position that they would have been in but for the violation. Now, when it comes to human rights, you are almost never going to be able to restore a victim to the position they would have been in but for the violation. You can't restore life. You can't untorture someone. But what you can do is create holistic substantive remedies that are aimed at securing something akin to what they would have enjoyed, something that puts them in a similar place, even though it will never be fully the same. So we're talking about things like satisfaction, an acknowledgement of wrongdoing, an apology or a memorialization. It requires rehabilitation. That's economic, it's social, it's political, it's also financial and physical. You need guarantees of non-recurrence. The structural changes that either a state or a business needs to ensure that they don't repeat that violation in the future. And this guarantee of non-recurrence is particularly important for victims. Oftentimes you think that victims are going forward for the compensation, and we're gonna get to that in a second. But what they also wanna make sure is that no one else suffers the way that they have had to suffer. So that structural reforming and the adaptation of processes that are appropriate to securing rights for others is actually a form of reparation for those who have already been victimized. So satisfaction, rehabilitation, guarantees of non-recurrence. There is also justice, which is through criminal proceedings, and I'm gonna come back to that in a second. But it can also be through other forms of accountability. And then finally, you have compensation. And compensation has both material and moral harm to it. So it is supposed to be sort of the thing that wraps up all the other stuff that you can't possibly have secured through rehabilitation, restitution, compensation, or sorry, guarantees of non-recurrence or satisfaction. So it's moral and material harm. And that's what we're gonna be talking about a little bit more here in a second. The criminal case, by its nature, Sweden is actually doing its state responsibility here and securing remedy for the victims in a small portion by taking this criminal case. It's an important contribution, but it is not the start and end to the case. And it can't be the start and end to what victims are entitled to. Particularly in a case like this, where it leaves nothing, the potential for the fine in the Swedish case, in the criminal case, is all the assets secured through the operation in Sudan. That leaves nothing for the victims to pursue, as Egbert and Olaf have already noted. That effectively denies the right of victims to remedy. And it's not a unique problem in this case. It's unfortunately a very common problem that we see in these kinds of cases. So the US prosecuted Lafarge for its involvement in war crimes in Syria. Where does that money go? It goes to the US Treasury. And admittedly, it can be used for other victims of terrorism, but not for the victims in this case. And that's a problem. That's not an effective remedy. It's a contribution to an effective remedy. That criminal prosecution is important, but you need something more. You need something that is victim-focused. And that means you need the assets that are available. And anything that denies the collection of those assets, any intentional conduct aimed at manipulating your asset infrastructure so that you cannot secure remedy, is a means of denying that right to a remedy. The right to a remedy has a temporal nature, but it is not just instantaneous. It can be something that occurs over time. So this ongoing denial of remedy is something that you find repeatedly in international human rights law, and that the treaty bodies and the special procedure mandate holders and the UN guidelines all recognize is itself its own human rights harm. The right to remedy attaches to all human rights, but it is its own standalone right. And so this ability, when you kill someone and you don't immediately remedy them, that lack of a remedy is itself its own violation, but it means that you are also constantly violating that right to life. You are failing to secure what is necessary to ensure that respect. And that's why the guiding principles put remedy as the conclusion of human rights due diligence, not its own separate process. It is a recognition that you cannot realize any human right unless you recognize and secure and protect that right to an effective remedy. Mergers and acquisitions, and I'm going to leave most of the mergers and acquisition stuff to Anita. But mergers and acquisitions, when you are looking at what you are doing in terms of acquiring another business, when you are examining what that is going to mean from a human rights perspective, first of all, generally, now we both have our own mergers and acquisitions consultants that we've talked to, and mine was like, I don't even understand how this is a problem. Of course they would know that they're denying remedy. And I was like, I know that they know that they're denying remedy. And he's like, that has to be something that's disclosed in the process of mergers and acquisitions. And they were a little bit flummoxed. The idea that you could have a business say, we're going to sideline this. We're not going to take any responsibility for this. And it can't possibly be part of what we have to account for from our human rights perspectives. But when you look at corporate restructuring, and it's not just in terms of mergers and acquisitions, it also comes up in insolvency, it comes up in a lot of other means in which businesses manipulate their identity and their assets for the purpose of denying victims a right to remedy. Anytime that you have its own distinct breach. And at times, that distinct breach is one of the most salient breaches that you will be facing. So when we talk about human rights due diligence, when we talk about what we're supposed to be assessing, we do allow businesses to focus on salience, but if you are talking about the denial of remedies for war crimes, the denial of remedy for the breaches of the right to life, for breaches of the right to freedom from torture, you are fundamentally talking about breaches of the right to life, breaches of the right to freedom from torture. And you cannot get much more salient than that in terms of a risk. So that has to be a part and parcel of the accountability that you do through your due diligence, and any failure to address that is a failure to do your job.
Thanks.
Anita, yeah.
Great, thank you, Tara. And as I see many friends and colleagues, it's been a long journey, right? So Tara mentioned that, a lot of this comes from the late 1990s, early 2000s. That's when I got into the world of business and human rights, because my work focuses on conflict economies and business and human rights and corporate accountability. And I think now, first of all, that we're still dealing with these issues that I remember when I was a lot younger and my hair had no gray. But now we're in a new spiral of new conflicts. And so I think, the journey and these issues become relevant not to just remedying the unpaid debt, right, and the past, which Swedwatch and Pax and others are focusing on, but the issues are alive for a new set of harms and a new set of claimants and victims around the world with the conflicts. And these conflicts that exist now are in some ways replicating much of the past in terms of the engagement of the private sector. So have we learned anything? But I'm going to now get a little bit technical and say what I did. So Tara filed an expert opinion in the NCP case, and I was asked to file one as well, and did focusing on the issues of mergers and acquisitions. And can a company do what we heard about, right? Can you actually just spin liability and then say the company that's sort of the acquiring or the merger say, well, we don't have responsibility? And so that's the first issue I'll address. And the second one is that there was also an indemnification clause. So you'll remember a moment ago we heard that sort of 98% of Lundin's assets were sort of in the merged new entity, with this 2% spun off into this little, the little company that only has a certain amount of money, kind of coincidentally similar to the initial criminal fine that was estimated. And so the question there is that company has provided an indemnity clause to the new merged company, saying if there are liabilities, we'll be responsible. And so I'll address the impact of that as well. But as Tara said, I think the larger issue for all of us is that their corporate law is being used now. And I'll just say again, I'm old, so a song that's in my head, I was telling Tara earlier right now, is one by a band called The Spinners, and the song is called Games People Play. It's in my head, and I'm sort of feeling that about the sort of tactical moves as we think about corporate law. And in the US, for example, as Tara was mentioning, corporate law is often used as a way of avoiding liability when it comes to human rights claims or to, tort liability. An example of that in the United States is something called the Texas two-step, which some of you may have heard about, which is that if a company is sued in a class action, let's say like an opioid case or something, in Texas, you can spin off liabilities into, again, a subsidiary, and then that subsidiary can declare bankruptcy, right? So that, again, it's similar to these situations of that entity isn't going to be able to satisfy the claims of plaintiffs, right? And so I think for all of us, kind of what these laws and what they permit and how they relate to human rights is sort of the next frontier, is that we have to examine that. And you can find in different jurisdictions around the world certain exceptions to that. Because unlike, as Tara, your M&A lawyer, your insider, right, said, how can they do that? And the answer is they often can. The target company in a merger, the liabilities of that company, even for things like products liability, can legally rest with that company, and the rest of the assets can be transferred. Not always, not if there's fraud. I mean, there are a variety of things, but just to say, as a starting premise, the law is not coherent in a way that we would think of when it comes to protecting human rights and providing access to remedy. So I just want us to say we need to start there, and we do need to involve corporate lawyers in these discussions to sort of talk about the fact that corporate law is denying remedy. So that's the starting point. But then we get to the issue of, well, how does that relate to the guiding principles and to business and human rights? So Aker has made public commitments on its website to the guiding principles, to the OECD guidelines, to respect for human rights, to conducting human rights due diligence, and to providing remedy. I mean, it's all there, right? So there is an affirmative commitment from this entity to engage in a human rights respecting business operation. So it's there. So in the context of remedy, in the case of these plaintiffs, what does that mean? We don't know. And if you read the NCP complaint, it's not clear that any human rights due diligence was done as part of the merger, right? That there was due diligence in terms of financial risk, but due diligence in terms of human rights issues wasn't necessarily there. Well, what should have happened? If a company is committed to the guiding principles, well, under Guiding Principle 17, you can read the commentary, and the commentary mentions mergers and acquisitions, right? So it's not hard to find that, it's there. So there's enough already in sort of established language and guidance to say that business relationships and human rights due diligence also are triggered when it comes to mergers and acquisitions. So that's a starting point. So there is a duty to conduct human rights due diligence. And as Tara said, it's not something hard to find. Guiding Principle 17 also has in its commentary the fact that if a company, so the target company being acquired, if there's implications in international crimes, then civil liability, that there may be people who have civil claims as well. So again, you don't even have to do anything more. Even if you're a lawyer that didn't know anything, Guiding Principle 17 puts you on notice that a company being acquired with executives being prosecuted, there's likely civil claims out there. So that's the starting point. And my opinion addresses this. But then the question is, well, what does it mean in terms of human rights due diligence? The starting point is that if a company is acquiring another, there's at a minimum direct linkage, right? That there's a relationship between the company that's taking over another. And with that direct linkage comes this responsibility to inquire and to engage. And here is where, again, what is interesting, and I'm not going to read the full quotes, but it's just to say that at the time the guiding principles were published, the Office of the High Commissioner for Human Rights published something that, again, I'm sure all of you spend all of your time reading because it's just so exciting, is the interpretive guide. Now, the interpretive guide is like a companion piece to the guiding principles. And in it, it specifically addresses the issue of merger and acquisition. And not just merger and acquisition, because again, if you think about mergers, right, there's always the risk of ongoing harm, right? If you acquire a company, you're worried about its supply chain. Is there forced labor? Is there something to remediate or mitigate? But this deals with the specific situation we're in here. If you're acquiring a company that has caused or contributed to human rights abuse, then you actually have to address that as part of the merger. And not only address it, but if the company you're acquiring hasn't remediated, then you have to. I mean, the language in there, in the interpretive guide, is actually pretty clear. So it's just to say that this is the larger issue, that there was an affirmative obligation, which the company itself undertook to conduct due diligence. And through that due diligence, if you find out that there's a potential contribution to human rights violation or abuse, then you have to address that if it hasn't been addressed already. So that's the larger issue. And I think the is, how does human rights due diligence and the guiding principles sit alongside legal requirements? And I think there we have to say, if a company has affirmatively taken the step of saying that it adheres to the guiding principles and it adheres to the OECD guidelines, and it has as part of its own stated policy certain processes, then we go into this step, which is to say that mergers and acquisitions in the context of the guiding principles requires you to address these things, right? So that you can't use sort of corporate law permits X as a way of avoiding your own affirmative human rights commitments. That's where we are, and that's the larger issue. And again, in the opinion that I wrote, there's enough, I think, additional authority, and also companies who have policies around mergers and acquisitions and issues of remedy, right, addressing remediated claims as part of that M&A, to say that this issue is not, we're just not sitting here kind of Tara and Anita just making it up, right? Because we're not. So I think that that's the issue, and interestingly. Similarly, indemnification. Indemnification is between the two companies. It's like a reimbursement. So if Aker was to provide remedy, maybe it could look to the spin-off company, although that company has no assets, to get reimbursed later. But that's not something that plaintiffs or claimants need to worry about. That's not their issue. So the indemnification issue as part of the complaint or part of the company's position, to me, seems to be just sort of distraction, because it's not really about what rights holders have. So I'm just going to stop there and say again that really, this is what we're looking at is established human rights law on the right to a remedy, and then what are the obligations relating to human rights due diligence and issues of providing access to remedy in the context of the guiding principles. And there I think it's pretty straightforward if you actually look at the commentary that we have. So with that, back to you, Salil.
Yeah, we will be taking questions from those gathered here and also from those who are on. But I had one layperson's question for both of you legal scholars here, which is this, that I hear you when you talk about the interpretative guidance, but couldn't a corporate lawyer simply say these are assertions, these are not binding in any way on us? So while you're asking us to do the due diligence, it's still a process. And the company can still say we did the process, and then the outcome of which was what the victims and litigants would be interested in, but we felt that it was a fair transaction. So does it mean that we need a legal trick through some legislative framework somewhere, which will require that a merger and acquisition that is planned specifically with a view to avoid these kinds of liabilities will be against the law? I mean, can something like that be done? Is that where we are headed?
So, and that I should have picked up on this in my initial remarks, but I think another kind of nested question we have to look at is, as we move into regulatory due diligence, mandatory due diligence, and if that mandatory due diligence provides for access to remedy, then we may already have that, right? That you look at the obligations of a company to conduct human rights due diligence and to effectuate remedy, and you read that in line with what's required. So I think mandatory human rights due diligence may already provide an affirmative or create an affirmative obligation for companies to act. If not, that was I think my opening statement is to say, in the area, especially, I've been looking more at the insolvency law rather than mergers and acquisitions. In jurisdictions all over the world, there's going to be a need to take a look at how corporate law is or isn't denying remedy, and then thinking about the policy fixes that we need.
Yes. So at the heart of your question is, do we need mandatory human rights due diligence? And yes, always, everywhere. But moving beyond that, do we need something specific? I don't think we need a specific thing around insolvency, but we do need to reform and educate insolvency and corporate lawyers. You know, I think we still have a small number of lawyers in the world who, during a mergers and acquisition, would even flag up human rights due diligence, regardless of how committed the corporation says. And that's a problem. Similarly, I have a piece coming out on insolvency and human rights due diligence shortly. I have to admit here, I'd never wanted to do insolvency law. I am regretful and resentful of the entirety of corporate law right now for the fact that I had to learn insolvency law. But it's coming out because in the insolvency law community, they're looking around going, we know that what's happening isn't right, but we don't know what the solution is. And I'm like, human rights due diligence, not for everything, but you know, it's a small component. And so hopefully, through better education and through better integration of corporate lawyers, like mainstream corporate lawyers, into these discussions, we can get further. Now, as to the question of, it's not binding, so doesn't that mean we can do whatever we want? No. Like, I mean, you still have to have something. If you're going to claim that you're committed to UN guiding principles, that means something. And it doesn't mean whatever you feel like on a Monday or a Tuesday, because if that were true, then I would assert that Amazon's human rights due diligence is to give me all of their money. And so it means, like, this means something, and international law means something, and there is legal content to that. So if you want to make the assertion that you abide by or you are committed to, that carries with it the expectation that you follow the interpretive guidance, or you have a really strong reason not to. And we don't like it is not a strong reason. It has to be something of, you know, we've now looked at this in light of something else coming from the UN Human Rights Committee or something else coming from the Committee on Economic, Social, and Cultural Rights. There has to be a reasonableness to that dissent, and we're not seeing it in this case.
Do we have questions online? Not yet. Okay. Joseph, Mark, and I'll take in bunch of three. Is that okay? So Joseph, Mark, and yeah, after that, yeah. I think we need to circulate the mic, right? Could someone surrender? I'm happy to surrender mine. Yeah.
I can do circulation as well.
Yeah. Okay.
The next step. Yeah. Hello. Thank you. I'm Joseph from SOMO. We ran into this mergers and acquisitions problem in the Telenor case as well, and it was, so I'm really glad that we saw this coming, of course, in this case too, which we've been working with Pax and Swedwatch on for a while. Another element, and we talked a lot about remedy and the indemnification issue, but what we really ran into in Telenor case was just information and lack of stakeholder engagement, and throwing that back to, oh, it's a merger, it's an acquisition, we can't talk about anything. We can't, they were disengaging from Myanmar with huge implications for rights holders Telenor was selling the data basically to a military company, so those people whose data was on the record at Telenor were going to be exposed. And we knew inside from the workers that Telenor was going to sell it to this military company, and Telenor kept mouth shut, and they wouldn't say anything. They wouldn't engage at all with the stakeholders, the rights holders, about the risks that were involved in this business decision, and it just kept coming. Every time we tried to raise this, it kept coming back to, we can't say anything. It's a business decision, confidentiality, sensitive. We can't say anything. Merger and acquisition. So we really ran into it there too. So it's and I guess that's and I wonder where this is going to go with the legislation now too, when these types of law, corporate law and human rights law, responsible business conduct laws come into conflict with each other. And you see a lot going back to, well, this is a business confidentiality decision. We can't do anything. We can't provide more information or whatever. So I just wondered if you had run across that, I'm sure in different cases as well. But that was something that we really ran into pretty harshly in the Telenor case. Thanks.
My name is Mark Taylor. I'm with the Clooney Foundation for Justice. And we've been playing a supportive role in the Lundin case, both supporting the lawyers for the plaintiffs for the victims in Sweden, and also supporting the NCP case in Norway. And really those, excuse me, those two, my question is around the responsibilities of those two countries as states, because you quite rightly pointed out, Tara, that Sweden is kind of fulfilling its responsibility by proceeding with a criminal case, but in the case of Norway and in the Aker acquisition of Lundin's assets in Norway, and given the fact that they've done this Texas two-step, they've done this kind of classic creation of a separate entity to move the assets out of the reach of victims. What potential role can the state play here, both in Sweden and in Norway? Is there anything that can be done?
Thank you, and thank you for hosting this panel. So my name is Thijs van Brussel. I work at Deloitte nowadays, but I used to be a colleague of Egbert at Pax. I was wondering if you look at the responsibility towards remediation, I think it's also closely linked to the connection to an impact. So if a company is actually contributing, of course, the responsibility is higher. And if the company, as I understand, is denying everything and also the actual impact taking place, then what are the options in getting to a point that they accept that they might be contributing to the actual impact? And I was wondering, is that also part of the NCP complaint, for instance, because that might be a body that can assess something like that?
First question is on Telenor. Who would like to take that? And the second one is on the state role. And finally, maybe Egbert and Olaf, you might want to address the final question. And you can, of course, add to that. Yeah, we'll come back to you. Yeah, I'll come back.
All right. So starting with Telenor and this broader problem of lack of stakeholder engagement. Your business confidentiality is not a get-out-of-jail-free card. I generally, when businesses bring, and Telenor is one of those classic cases businesses often bring to me and say, look at how unfair you are to us, Tara. How would you have possibly handled it? And I said, you can get a lot from stakeholders without telling them a lot. Sometimes you need to tell them a lot, but you can learn a lot about stakeholders. It's not a breach of confidentiality to say, how do you feel like we should handle your data in this merger and acquisition? Would you have concerns about who the company is going to be sharing your data with? What kinds of concerns do you have? Stakeholder consultations do not always need to be a disclosure of all the minutiae details, but they do need to have a broad sense of what the risks are. And asking them questions is what it should be about. And learning from them and gaining their insights is a huge component of human rights due diligence. So you can learn a lot without having to do this. In this case, you didn't even need to do that part, right? Like, you know that there's an investigation that's out there. This was not a secret. You just had an indictment a month beforehand. It doesn't take a lot to figure out that you need to be aware of the right to remediation in this case. You need to be aware of the rights of victims. You need to know that they are out there advocating for this, that they've been advocating for it for 23 years, longer than that. This was not a secret. This was not an issue where confidentiality was an issue. And so both in this case and in Telenor, it's not that the merger and acquisition in and of itself is a problem, but it is how the merger and acquisition that was done that is the real issue. On Mark's question of state responsibility, anytime the Scandinavian states are following Texas, something has gone horribly wrong, right? Like, that's not the way that progress or life should ever be. And so Norway's allowance of this as a legal tool, Sweden's allowance of this to take place is itself a failure. It's a failure of the states to take seriously their own human rights responsibilities, to regulate their corporations in a way to secure respect for human rights. It is particularly distressing. I had never considered how much it would cost. I knew that it would be a lot for victims to pursue this on their own. And it's why I love civil law states so much, because you can attach these civil law claims to criminal prosecutions, or you're supposed to be able to. And in doing so, you make remedies more accessible. And then to find out 50,000 euros each for 32 victims from South Sudan, like, you want Jeff Bezos to pay 50,000, like, that's chump change. You're going to victims in South Sudan, people whose lives have already been terrorized so severely, and saying 50,000 euros, please? That's beyond the pale. So you're seeing a collective failure here. And it is a failure that involves two businesses and two states, and they all share a part and parcel of this. And so my hope is that if this doesn't go forward in terms of getting real accountability from the businesses, I hope that the states are eventually held accountable for that severe breach in responsibility.
Yes, I'd like to say something also about, I mean, we're now talking about these 32 victims. Of course, there are about 200,000 other survivors of war crimes out there. And they have certain expectations. I mean, they're very distant. It is, of course, their sources of information are extremely limited about what's going on in Sweden. But it's key that they also find justice and can exit justice. Now, one of the problems here is that it was impossible to attach claims of such a large group in this trial. But we're hoping that in case of a conviction, we will be able to do so anyway. One of the problems there, and there you see the consequence of because that's another disbalance, because the amount of money that the company spends each year on legal defense is $8 million according to its own budget. This is much higher than even the prosecution has at its disposal. Not even talking about, of course, the plaintiff's lawyers. And so there's a huge imbalance in terms of legal artillery that they can bring to the battlefield. I think what we would be needing is about anywhere between $2 and $4 million to be able to bring some sort of a class action suit in Sweden. So if there's anyone in the audience who has that, or anyone online who think he can help doing that, please get in touch with us and we'll make it happen. Thank you.
We have 4 more questions, so if you can keep it brief. Yeah.
Oh, no, I was going to say, I just have 3 quick, on the secrecy, states, and contribution questions. Back to the contribution question, I addressed that in my opinion, which is that essentially the issue of a company is directly linked when it begins a merger process, and it needs to conduct due diligence. Either conducting and then not acting on what you find, or just not looking, can bring you into your own contribution. So basically failing to address what you discover and addressing remedy. And again, that's where you have enough guidance that is coming out around the guiding principles and guiding principle 17 that really focuses on when a company moves from being directly linked to contributing to the denial of remedy. So I think that is fairly clear. Joseph, just one more point on secrecy. So I think Tara's point about you can still consult stakeholders, right, in even when there's business confidentiality. The other piece is when it comes to challenging environments, right, where this is going to become a bigger issue, then it's also, I think, incumbent upon companies to have, as part of their stated human rights due diligence policy, actual plans around how they're going to address mergers and acquisitions. This is the larger issue, right, is that needs to be communicated, identified, and you consult stakeholders even then about what if, right? And some companies, in the extractive and oil and gas sector do that. So I think that's the other piece of that, right? So that you're prepared for that eventuality. States, I think, And we need to look back to mergers and acquisitions. The time to have addressed this issue was when the merger was approved, right? I mean, and you can imagine that there could have been some kind of requirement of a bond or a posting of funds to adequately address the potential claims, right? So that's, I think, my answer there.
The lady here was first, actually. Her hand was up. No, oh, you don't want? Okay, all right. Then it's the gentleman there and then the two at the back, yeah. Okay.
Hello, my name is Jenny Alstrom and I work for the Agency for Public and Financial Management in Norway. I just wanted to hear if you have heard about the Transparency Act, the Norwegian Transparency Act, which came into force 2 years ago, actually. And this summer, the companies were having to report publicly on their human rights due diligence. And any person is allowed to file complaints to the agency for what's it called? Customers' rights. And the law is linked to fines. So if this agency finds Aker here responsible for not failing to do a risk analysis, it could be an interesting case there. So far, no company have been getting a fine, but I think this could be interesting to test the Norwegian Transparency Act.
The gentleman here, yeah. And there was one more, right? And that's you. Oh, there are two more after this. Okay, and we'll take those two and then. So you and then you, yeah.
Hi, my name is Alan Warner. I'm from Civitas Maxima. I have two questions for Egbert. The first one is about decision from the Supreme Court, as I understand in the case, where I think it was in December, if I'm not mistaken, where actually one of the defendants is from Geneva. Alex Schneider is Swiss citizen, and he doesn't live in Sweden, and obviously the case is in Sweden. So, of course, his lawyers fought to say that there was no jurisdiction on him because he's not in Sweden, he's not Swedish citizen. So if you can maybe, because this is very interesting for us, we are litigating cases, so this is very interesting as a jurisprudence. And the second one, and it was not addressed, and I think it's a big concern for everybody, the defendant, obviously the victims, is the length of the case. So we understand it's until February 26, which even in UJ cases nationally is never that long. I understand it's 3 days a week, but with the number of victims, I still do not understand how it goes all the way. The defendant has to go, I think, in a private jet from Geneva every week. And what about the victim? I cannot even imagine. So how come I don't understand how Sweden didn't manage to get that trial? How can it last until February 2026? Thank you.
The back and then in the front, yeah.
Thanks. My name's Catherine Booth, and I work with Joseph at SOMO, but I also spend most of my time with OECD Watch, which works on OECD guidelines and these sorts of complaints. So my question is it's to Egbert and Olaf, really, looking backwards and looking forward. So Pax has been working on this for over 20 years. What led to the filing of a complaint to an NCP? So looking backwards, how did you get to this step? And then looking forward, Egbert just mentioned that there's talk of a class action, but how are you going to use this process, potentially some sort of statement in the NCP's final statement? Like, how are you going to take what you've got from this NCP process into the future?
Last question in this round in the front, and then we'll have answers. Here, yeah. Are there other hands at the back? I just want to know. Can you wait till we do one more round of answers? Yeah, it'll be too much. Yeah, so let's have this question, quick responses, and then we come to you.
Thank you. My name is Camille Leroy. I'm with Open Society Justice Initiative. I had a question, well, a thought actually based on something Anita mentioned earlier with respect to the necessity to look at the corporate law around the world to see whether it's denying remedy and how we can address that. I was just thinking, based on my experience as a Belgian lawyer, based on a system, criminal law system there, whether it wouldn't be a possibility to push for states based on their responsibility to ensure remedy, to push for states to include in their criminal procedure system clauses that, well, provisions in the law that allow investigative judges to prevent these types of mergers and acquisitions to happen in certain circumstances. And the reason why I'm asking is that because we have that in Belgium in the Criminal Procedure Code in certain circumstances where a company has been indicted, well, different type of scenarios, the investigative judge can block this from happening. I'm just thinking, well, obviously we would want corporates to do better human rights due diligence, etc., but perhaps there's alternatives to making this happen.
Two clearly for you, the two of you, and the other two are for the two of you. So let's do it that way.
Yeah, regarding the Norwegian transparency law, yeah, we did talk a little bit about how these, the NCP process and the kind of the process of the transparency law, how they would relate to each other, I guess, and then I don't know if that's completely clear, but this merger was completed, I think, about a month before the Norwegian transparency law came into effect. So whether it would be covered or not, I don't know if there's a precedent on that. But I think, I mean, right now we're awaiting the final opinion of the NCP, and I mean, once we have that, we can pursue other avenues, potentially the Transparency Act.
And Egbert, you have two specific questions. One is about what you've learned, and the other is about, of course, why is it taking so long, and the specific case of the Swiss individual.
Yes, the decision by the Supreme Court in Sweden to allow the court to judge, to say that Sweden has jurisdiction over Swiss national, was hailed as a triumph by many international lawyers and observers, because and it's an important decision because the defense they have very impressive legal opinions by very eminent lawyers to back up their claim that there was no legal opinion that went back to the very origins of international law, etc. But it was flatly thrown out. Though there are lawyers who warn that it may not be such just a simple clear victory, because the judgment says that there must be sufficient connection to Sweden. Didn't qualify what that means. It just said that in this case, because it was serving as a director of a Swedish business, there was sufficient connection. But that question, what is sufficient connection, remains in the air. But otherwise, of course, it was a really huge victory for the prosecution. Then about the length of the trial, that has to do with a bit of an old-fashioned criminal procedure as in Sweden. All the evidence has to be heard in court. So that's why it takes 2.5 years. There are few, if any, written procedures going on. I know only from my country, the Netherlands, where it's the opposite, where you can have hearings where hardly anything happens in court, which is kind of also a bummer for for many people. But this is the opposite. Everything must be said in court. That's why it takes 2.5 years, which by all means would seem excessive. Yes. And about the Transparency Act also, we are arguing in our submission. I recommend to go to our submission and the two legal opinions by Tara and Anita that are on the website, unpaid that. In our submission, we are also claiming that Aker is currently today failing its due diligence obligation, because due diligence should be an ongoing process. And so after the 1st of June 2022, there's still a due diligence obligation, which they're clearly failing. So in that sense, the Transparency Act may be invoked by us when we have time to do so. Thank you.
You want to respond to what have you learned? That question. Yeah.
What we have learned. Yeah. Well, I'll say something else. Our focus is the victims, and they are totally absent from the consideration of the court. They're totally absent even in the proceedings. They have no face, they have no personality, they're nothing. If you look at this decision by the court to throw out the civil claims, that's another one. But I believe that the request by one of the lawyers to basically to say that one of the judges, the president of the court, is biased. It comes down, I think he focuses most on the fact that the court really objects that 5 powers of attorneys of his clients are not yet there, and they must be there in hard copy. And they were only informed about it 2 months before the start of the trial. And the court seemed to think that in South Sudan you can just you write something up, you stamp it, you put your signature, you put it on the post, and you send it to Stockholm. Yeah, this is totally ridiculous. There are no post offices in South Sudan. There are no roads from where most of these people live to Juba, where you may find a post office. It's physically to get a paper signed by someone up in Unity State in the block where or even in one of the refugee camps in Uganda or Kenya, wherever these plaintiffs live, and to get it to Stockholm is impossible. Yeah. So there's such a mental gap and such a lack of understanding, not only what happened in those days and their logic, but also even what the fate and the situation of these victims are today. I mean, almost 10 of them have gotten refugee status outside of East Africa because they were harassed and intimidated. They've been plaintiffs for, they've been officially witnesses for many years. They've gone through terrible times because of that. And of course now they're accused by the defense that they're all doing it for their, because they can make money, which is pretty ridiculous if you look at the hard times that the fact that they are witnesses has given them. There's a total, I don't know. I'm always amazed how much people can live in a bubble of their own world that they know, and how little they can understand, but also how little. It's so hard to get any South Sudanese to Europe, and then you have to find people who actually speak English, and then make them understand the court, what life was and is now for them today would be vital. Will be very hard to do.
Anita will respond to the OSGI question, but before she does, Egbert, just to remind, when Guzman Kuvenhoven was being prosecuted over the conduct in Liberia, I remember when the case was finally thrown out, one of the things the judges said, the judges who were trying the case actually made the statement that I can't believe that people just came and dropped weapons to people who wanted to have rebel forces. Surely there are customs which would have stopped this in Liberia. So I thought I'll recount that story. But Anita.
Yeah, no. I think Camille's point is an excellent one. And I think, again, one of the questions I always ask is, why are we dealing with these naughty intellectual corporate law challenges now? And the reason is it takes us so long to get to this case, this trial, that these gaps only become apparent now, right? And so John Ruggie many years ago did a project called Corporate Law Tools to look at corporate laws enabling us to do human rights due diligence and good things. And now I'm thinking, and Tara, you didn't know this, but you're going to be part of this too, is that we're going to have a new project called Corporate Law Challenges. Because, again, I think this is the next piece, right, is we're here now, and we now see that next tactical move, and we've got to figure out how to move around it.
Okay, we have 12 minutes, and I think there are 2 or 3 hands at the back, right?
Sorry.
Oh, no, sorry, 1 second, yeah.
One moment. Just answer your question about going forward. I mean, the final opinion by the NCP and how that will be used in the. I mean, that we don't know what the opinion will be yet. So, but I mean, I think it's absolutely essential to get clarity, at least on these issues, and kind of, yeah. I'm not a legal scholar, but I mean, the fact that responsibility for human rights can be kind of bought and sold and stowed away. That can't be right.
Thank you. So my name is Najib Bajale, I work for International Alert, and I want to follow up, Anita, on the corporate laws question. Just thinking, until we iron out all these challenges with them, there's going to be inconsistencies, especially as we got new due diligence laws coming through. So as a court, how do you or how should you be dealing with these inconsistencies? What precedent is there for who takes the sort of most importance when you are taking an issue like this?
Hi, my name is Evita Mieszkowska from Global Rights Compliance. And my question is also on the issue of the mandatory human rights due diligence that's coming into European legislation, in particular with the EUDR and the EU Triple Due Diligence Directive, and whether there is a significant concern that companies are going to get more creative in evading sanctions, especially given that it's the turnover of the parent company that is the target of the measures. And also, how can we engage better with corporate lawyers working in law firms on trying to remedy this particular issue of this corporate creativity?
Any more hands at the back? Or anywhere else? No? Oh yeah, one more. The final one in that case, because we have 10 minutes and they can respond to these and make their final remarks. And nothing from... Here's your chance. Those on Zoom or YouTube, if you want to ask questions, please be quick. But yeah.
Thank you. So in my experience with some of these, it's investors in these different projects are often confused. So for example, I'm aware of a mine that was purchased from one company purchased it, and the investor seemed to be confused of whose responsibility it was, the new owner or the old owner. So how do we provide guidance to investors on these topics?
Can we go like 1, 2, 3, 4? Oh, okay. You want to start first? Okay.
Yes. About investors, I don't think investors are confused. I think investors are not interested. It is absolutely unbelievable. We've been filing proposals at Lundin Energy's AGMs several times, simply requesting the company to do human rights due diligence on its alleged adverse impacts. They were, the first time it was thrown out by 82% of the vote, the second time by 99.2%. So far for the investors. I mean, the investors voted in favor of re-nominating as director suspects of war crimes. Yeah, for how much was it? For 5 consecutive years, by a vast majority. The only proposed directors who were kind of where there was some opposition against was because they had too many directorships in other companies. Nothing about human rights, nothing about war crimes. Yeah? So investors, please. No, I'm not impressed by these investors. And they are the fin de fleur of the Swedish financial institutions. Huh? A shame.
Yeah, and I also want to say that Egbert was there and I was there when they voted to merge with Aker, and there was no discussion around human rights. You know, free for anyone to pick up that issue, but nothing.
So we're doing final thoughts now too, right? All right. So I want to wait. So I'm going to wrap the questions and my final thoughts together. But I think Ashley just asked a really important question of whose responsibility is it? And the answer is kind of everyone's, right? If you are a business or if you are a state in this area, you have a responsibility. And you need to figure out what that is and do your due diligence to identify how far does that go. And that includes investors. And I have to say, I made a joke earlier about how Scandinavian states should never be following Texas. I stand by that joke, but I will say that when it comes to investor responsibility, I'm very dismayed at how far behind the US European investors are, institutional investors. When I go into US institutional investor audiences to talk about human rights due diligence or to talk about human rights, I don't convince them to have the conversation. There's a lot of ESG backlash. There's some political movements in the US that are deeply problematic. But the institutional investors, for the most part, have been having these conversations in the US for several years. And when I come to European institutional investor conversations, it's not the same. And I find that very distressing as somebody who has intentionally been in exile from the US for 15 years. I chose Europe for the belief in values and to watch it go out the door as soon as money is involved, as soon as it becomes an issue of actually having to pay the consequences or pay the price for respecting rights it's a sad reality. I realize that makes me sound a little bit idealistic. Don't worry, I'm about to get skeptical again. So when we talk about cause, contribute, and directly linked to in the UN guiding principles, those terms are supposed to mean something. You owe remedies if you cause or contribute to a human rights violation. But even if you're only directly linked to, you still have a responsibility to use your leverage. So let's presume for a second that Aker was only ever directly linked to. It's not. I'm going to explain why in a second. But the moment they start their mergers and acquisitions, they have a responsibility to use leverage to ensure that Lundin is recognizing its responsibility, that it is owning up. And that involves its own assessment of the facts. It involves its own conversation. But the moment you start to engage in a corporate restructuring of this nature, one that is designed to deny remedies, you can no longer absolve yourself from that responsibility by saying we're only directly linked to. The act of the corporate restructuring is what caused and contributed to the violation. And in this case, both companies are causing. It's a joint cause. It's not one of them is more responsible. Both Lundin and Aker have the responsibility now to remediate the harm that occurred. And each time they deny the remedies, each time they undertake this, it is a new form of harm. Egbert talked about the impact on the victims of having to sort of go to Sweden and speak English to convince a court of the trauma that they have occurred. And what we know from psychology and from trauma specialists is each time we tell a story, each time we tell a story of trauma of ourselves, we are traumatizing ourselves in a sense. It is a process that can be quite triggering. It's a process that's quite upsetting. And the same thing is true when you have to sort of shout into the wind on something like a corporate restructuring. To undertake this kind of a merger and acquisition is to create a new material and moral harm for the victims. So it's now not just about what happened in the late 1990s and 2000s. It's what happened in December 2021. It is that announcement, and then it's the carrying through today. So we are not talking about something that is historical. It started off as a historical reality, but we are talking about harms that are occurring now, that are continuing to occur, and this denial that comes from this action of the corporate restructuring. And that's why this case, it's not something that we can just dismiss as being an interesting case study. It's one that has grave consequences for the victims. And it's one that I hope that both the Swedish and the Norwegian governments take seriously moving forward in terms of the legislative changes that are needed. Quite frankly, I will do, for this entire table, it happens, this is very rare that I'm on an entire table where I would do almost any legal research that they ever asked of me. So yes, I will follow you into the depths of corporate hell, Anita. I will, however, draw the line at learning Swedish merger and acquisition law. So Egbert, you can ask a lot of me, but that one I'm gonna defer on. But when we talk about the legal response, when we talk about corporate human rights due diligence and mandatory human rights due diligence legislation, it has to be robust enough that these things fall within it. And it has to be creative enough to address the creative nature of corporations, because will they start being creative in how they do? They already have been, and they will continue to do so. And so the law has to be robust enough to respond to that creative manipulation, and we have to be sort of forward-thinking enough in the design of the laws and the legislative responses to prevent that corporate capture.
So just a couple, back to Tara's point about leverage, that's precisely what this is all about, was at the moment that the merger and acquisition was going to take place, you had an obligation, a company that was directly linked, Aker, to use its leverage to get Lundin to address remedy. And the minute it didn't happen, right, then you're moving away from directly linked into cause and contribute. That's it. And so that's the crux of it. But back to the questions from our colleagues from International Alert and from Global Rights Compliance, is like, how is this all going to work legally? And I think that's going to be a question, right? We have conflicts of laws and choice of law, which law applies. But we have to remember first and foremost that for companies that have taken this step of making any commitment, whether it's to the Global Compact, the guiding principles, OECD guidelines, or even, let's say, an industry code, if they've already that step, then just choice of law in affirmative responsibilities. And again, it's not to say it's an easy analysis, right? It brings us into duty of care and other things, but just to say that that's the first step. The second step is then we all need, and I think this is Tara's point and it's my point. And again, this is decades for me, right? I'm kind of getting exhausted with these sort of intellectual puzzles that kind of come at you. And I'm like, is it maybe the cure for preventing senility? Maybe that's about it. I think, because I'm always like, wow, it's like I have to wake up. But we do now need to actually look at mandatory human rights due diligence laws with a new lens, right? We haven't been talking about this part of the corporate transaction at all. And my notes are go home, look at the drafts, and say, are they fit for purpose to address these issues, right? And so that's Tara's point, which is that we have to anticipate now this type of activity and seek to sort of preempt those arguments.
Thank you. It's been a lot of thought about the steps ahead. The takeaways I had, and there are many, but the ones I can think immediately of, is that patience matters, perseverance matters, not forgetting the victims matters, due diligence matters, both of who the investors are and how they operate, and continue to pursue them and persuade them about what they ought to do. Understanding the difference between on the two sides of the Atlantic about how companies and investors look at issues differently matters, as well as legal research, which goes deeper and deeper into unpacking things. And the affirmative responsibility matters in the end, because we do need to look back at the UN guiding principles, not with a view to elevate them to a level as though they're set in stone, which in a sense they may or may not be, but how they can be interpreted more creatively for this affirmative responsibility. And finally, I think we must figure out a way so that we all have a tool in hand so that transactions which are intended to frustrate human rights remedies are no longer possible. Thank you.